Okay, welcome back, everybody from lunch. To kick things off this afternoon, we have a lightning talk followed by a panel. For our lightning talk, we have Cadet Genevieve Sabato providing a presentation on national security and space communications. Cadet Sabato is from Pomona, California, and is a member of Cadet Squadron 24. She would like to become an Office of Special Investigations agent or intelligence officer upon graduating from USAFA. She would also like to pursue law school at some point in the future with a particular interest in business law. And most importantly, she's one of my current students. So take it away, Cadet Sabato.
Hello, everyone. I am Cadet Second Class Genevieve Sabato. I'm from CS24. And today I will be talking with you about the legal implications of space communications using a hypothetical future scenario that underscores the importance of relying on existing law to address to help inform our approach to certain space domain issues. So time travel with me to the year 2070. Humanity has established colonies on the moon. The different colonies are representative of roughly 25 different nationalities, including the US, Japan, India, China, Russia, etc. However, state actors are not the only ones establishing colonies on the moon. Private companies have established their own colonies. In this 2070, Elon Musk has established his own colony on the moon. It is known that these colonies have established their own means of communication between one another using a new SpaceX satellite called Lunar Link. I know, it's super creative. We can agree that these communications between Elon Musk or SpaceX or his lunar colony and other states' colonies, such as, I don't know, China or Russia, would pose a national security interest for the United States. The question presented is, would it be lawful to gather intelligence on these communications? And I'll give you the best lawyerly answer there is. It depends. I'd like to bring your attention to the Foreign Intelligence Surveillance Act, FISA, specifically Section 702. Section 702 provides that targeting is permitted for non-US persons. It also provides that targeting is prohibited for US persons. Targeting is prohibited for anyone in the US, and reverse targeting is also prohibited. My interpretation of Section 702 is that so long as residents of this moon colony, Luna X, do not renounce their US citizenship to become a Luna X citizen, the US cannot lawfully gather intelligence, nor can they target a non-US citizen with the intent to gather on a Luna X resident that is a US citizen. That's the idea of reverse targeting that Section 702 prohibits. However, if Luna X residents decide to renounce their US citizenship, then it would be lawful for the United States to target and gather intelligence on them, as they are not provided protection covered in Section 702 of FISA. Yesterday, the panelists discussing the future of normative international law and space governance talked briefly about the idea or the value and significance of wording and how diction can deeply affect the application and interpretation of the law. I'd like to hone in on this topic, or this idea of wording, and emphasize the significance of the language used in FISA Section 702, particularly highlighting the prohibition of targeting United States persons, not citizens, but persons. This distinction is crucial to note, as persons encompasses not only citizens, but also legal entities, such as corporations who are granted legal personhood. Given that Mr. Musk's SpaceX is incorporated in the US, my understanding of FISA Section 702 is that the US government may be legally restricted from collecting intelligence and targeting SpaceX communications conducted through this SpaceX satellite. even if the communications or the people communicating are not legal or US persons. The restriction stems from the prohibition against targeting and gathering intel on US persons where corporations treated as legal persons fall into this category. Thus, Elon Musk, SpaceX, and communications conducted through SpaceX satellites are protected under Section 702 of FISA. So essentially, the intricacies of the space domain present significant legal challenges. We've explored a hypothetical scenario regarding the legality of intel gathering of a corporately established lunar colony and its communications. We reach potential conclusions or outcomes by relying on existing law to provide a framework for addressing legal issues in a novel domain. I believe this is along the lines of what the next panel will be discussing and how the development of different types of law can help inform future space operations law. And I'll leave it to them as they're much more knowledgeable than me. I'd like to conclude this by thanking Professor Davis and Major Bradford for this incredible opportunity, and as well as DFL for being the best department there is out there. Thank you for your time, and I hope you enjoy the rest of this conference.
Thank you very much, Cadet Sabato, and for that rousing approval of the Department of Law. And I promise this isn't a quid pro quo, but I'd like to give you one of our conference coins. Okay, our next panel is titled Parallel Lessons Learned, How the Development of Intel and Cyber Law Can Inform Future Space Operations Law. To moderate this panel, we have one of our conference organizers, Major Sandra Ahinga. Sandra is currently the Chief of Administrative and Civil Law at U.S. Space Command. Prior to her arrival, she earned an LLM in National Security Law with a space focus from Georgetown University Law Center in Washington, D.C. During her time at Georgetown, she pioneered an LLM space law-specific externship in the Office of Legal Policy at the U.S. Department of Justice. Over to you, Major Ahinga.
Thank you. Welcome back from lunch, everyone. I'm so nervous to have this conversation because I have an abundance of legal expertise on the stage, and I think what I'm going to present to you is a bit of organized chaos that speaks to, and I think Captain Pascucci has specifically promised this to me, all of this will speak to legal lessons learned, parallel lessons learned from the perspective of Intel and cyber, and what we can take from those places, from those practice areas, and carry them forward into space and how we advise on space. And I think I'd like to frame it from the rubric that was set forth by Honorable Crass and pull out 2 points that she made. One, and first is what does multi-domain lawyering look like? How do I do that thing? What questions do I ask? Where do I place myself? Who do I talk to first? And then second is essentially advising our future selves. So she pulled out the legal frameworks for novel space activities. What does that look like? How do we advise our clients on how we inject flexibility into the statutes that we will advise on or inform from our agency levels going forward? In terms of policy as well, how do we create those underpinnings of policy with the framework of law and advise our clients to help us create a situation where there's flexibility in the law and we're not having to go back and overturn or change in significant ways that which already exists, and that can move and flex with how our capabilities develop. So this discussion is essentially a recognition that it's not necessarily all new. Intel and cyber have challenged us in cross domains in very similar ways that space does. So we want to learn from my folks on my team here what they've taken from those areas and what we can carry forward. So to set expectations, we will answer no questions. All of this will be about questions, right? It'll be about the inquiry that we all do on a daily basis to sort of figure out what this thing is that our clients want to do or develop, and how we fit that into a legal framework that sort of takes care of all of the issues that come with those sorts of things. So Our panel members, they are chosen because they have that sort of cross-cutting experience. So they're in space and cyber and intelligence law. They have studied emerging technologies and have advised on them. And they've taken it from authorization through execution into evaluation. So they bring perspectives from criminal law, from academia, from the interagency, and from, of course, the DoD. So I have on the stage with me Professor Leonard Bailey from the U.S. Department of Justice, Professor Donahue from Georgetown University Law Center, Lieutenant Colonel John Goehring from National Geospatial-Intelligence Agency, Captain Peter Pascucci at Fleet Cyber and Navy Space Command, and Mr. Todd Pennington, Associate Deputy General Counsel for Intelligence at DoD OGC. So I kind of want to start with the multi-domain lawyering piece. And I'll tell you, my biggest fear is that I don't know enough. I don't know enough about the capability. I don't know what questions to ask. I don't know necessarily much about the activity. So I want to start there. And I understand that an aspect of multi-domain lawyering is staying astride with the space capabilities and their operations. How do I do that? So I kind of want to open that to our DoD folks first, and Mr. Pennington. You have direct experience in advising in cyber and intel operations. Looking back on the development of those activities and the development of those capabilities, what would you have wanted to know? What would you have done sort of differently? What questions might you have asked that would have helped you sort of set yourself up for success in advising on these sort of cutting edge activities?
Sure. Great question. My answer, unfortunately, is not going to be really specific to space or intel or cyber. I think the things that I'd offer on that probably apply in most lines of national security lawyering, but probably more so in space and cyber when you're new to that mission area, which I've been new to each mission area. And so have some thoughts about that. One thing I'd recommend is an approach is to embrace the question that reveals your ignorance. Everyone, all of us as lawyers are good at asking the question, right? Even if it reveals our ignorance. But I think a lot of times we do it grudgingly. We do it out of a sense of obligation or necessity. And just embrace it, because when you're new to a mission area, there's so much you don't know that you don't know. You won't know the questions to ask. And just being very transparent about your need for understanding in that regard goes a long way. You know, with things as fundamental, for example, in space, how do orbits work? You know, when you're new to space, as an attorney working in a mission area, people will tell you about the Outer Space Treaty. They'll tell you about this is the difference in GPS and SSA, but no one's going to tell you about the two-body problem, which is the fundamental physics of why orbits work. And you have to ask that question, and you have to learn that. And so those really fundamentals are what asking that question that reveals your ignorance will get you, and it's a gold mine. And then you won't be ignorant anymore, right? That's the payoff. A second thing is to beware the us-them dynamic in working with various organizations. This community of practice is really blessed with probably the most collegial and cooperative working relationships of any in the national security enterprise, which is one of the great things about working in space. But there is still internecine turf wars between organizations. And when you're working with your clients on a matter, people are bringing their organization's perspective on that. And you need to be very eyes wide open about that. And as a legal advisor, you will advocate for your client's desired outcome and for their approach to a problem, but it pays to ask that question to sort of understand, where are they coming from? Is this about an organizational difference of views about how to approach this matter? Is this from about different organizational priorities between one organization and another? And try and take it from that principled perspective instead of us and them, because it's all us, right? There is no them in this context when we're working inside the community here. And then lastly, two things that really I think are so central for the DoD legal advisors in the room in terms of topical areas. And again, they're nothing to do with space, cyber, or intel. It's command relationships and fiscal law. Those two things, that is the practice of operations law, because command relationships is the essential puzzle piece, a puzzle that needs to be assembled that tells you who gets to make what decision, who gets to approve what activity. And that is so much of the process, is just getting that decision to the right decision maker and figuring out if your client is that right decision maker or if it's going to be somebody else. And then it all goes back to money. And so a lot of folks don't like to dive into the fiscal law aspects of our practice or get too queepy about command relationships. And yet that is so central to many of the issues and the resolutions of matters that come before us.
Thank you, sir. I'd also like to open it up to Captain Pascucci as well. One of the sort of goals of the conference was to get ahead or to catch up to how capabilities are developing by thinking ahead of it, right? And we're talking about space futures. How have you sort of positioned yourself, when you were new to this space, to be successful in advising?
Yeah, so thanks for having me. I will tell you the number one thing you can do is get out of your office. This is not going to come in via an email. They're not going to call you. And the capability fact sheet you get tells you about 20% of the story. Go actually find the people that build and operate the technologies you're dealing with, right? First of all, you will never come away with a better understanding for how it works. More importantly, aside from what they tell you what it's going to do, ask them what it can do. Because inevitably you will have some junior enlisted person who says, well, sir, it's designed to do functions A and B, but you know what's really cool? And that's when you start to get scared as the lawyer. And they say, when we put these two things together, it'll do this other thing that's just amazing, right? Because I will guarantee you that's not on the capability fact sheet. That will be what your operational commander wants to do, and that will be the legal questions you will have to answer, right? And so again, get out of your office, put on your OCP, go climb down in the basement with the engineers and actually play with the technologies. And if you learn it that way, you'll be much better positioned to, exactly as Mr. Pennington said, and work through those some tougher legal issues.
I'd like to echo that the points they both made about technology. I recall hearing someone on a panel one time asked about how they could be a better space lawyer, how you can better advise on space operations. And I thought, whoa, maybe I could have taken more international law in law school. Maybe I could have taken procurement law, because that's a huge aspect of it. But technology is key. Understanding the technology you're dealing with is a huge aspect to being able to advise in this area.
I'd like Professor Bailey, if you would. So you're at the Chief of Cybersecurity Unit at DOJ, and I've been in your class when you teach how the internet works in a really accessible way, in the sense that when I was in the room with you, I understood it. When I left immediately, it downloaded. How did you get to that place? Do I have to go back and get a degree in engineering, or who do I talk to?
So absolutely not. And I think this is one thing we say to everyone who comes to us as a lawyer. By and large, you don't need to be a network engineer to be a good cyber lawyer. You have to understand at the appropriate level of abstraction how things work, such that you're not going to do violence to the analysis, but you don't need to know every jot and jot of technology. One thing that has struck me, and I echo everything that everyone said already, so maybe twice a year, an investigator walks into my office and says, hey, can I take this website down? And then I respond, well, where's the website? How are you going to do it? What crime you're investigating? Where are the people looking at it located? And a battery of other questions, which is why we don't allow firearms in my office, because these are not popular questions. But at the end of the day, I have to explain, this is how I craft options for you, right? In many ways, as an operational lawyer, I'm your human shield. I come up with answers and options. Very rarely do I say no. Rather, the answer is, here are your options. Some of these are not going to be probably operationally feasible. Some of these may not be politically feasible, but you have the array of choices. And that's, I mean, that's, I think, the way an operational lawyer should approach the issue.
I'd actually like to ask Professor Donahue, from the, there's of course an ongoing conversation, and we'll talk privacy a little bit later in the conversation, but there is an ongoing conversation about FISA and the application of 702. And there is an underlying capability that, is used, or capabilities that are used for that. And I guess my question to you from that perspective is, like, if you were standing at the beginning of that conversation, what sort of questions or legal competencies might have been brought to bear to change the course of how that ended up, or where we ended up with respect to that?
Yeah, thank you. And thank you for the opportunity to be here as well. So, we often think about FISA as, a camel is a horse put together by a committee. That's kind of the state that FISA is at this point. Something that was created in 1978 when Get Smart, used a shoe phone as a joke, really doesn't fit the world that we live in now. So in terms of FISA and foreign intelligence collection, what we've seen, at least what I see in terms of similarities for the domains that you have to think about and deal with here, I really see three interlocking areas, right? The communications questions that are related, the sensor technologies and the deployment of these sensor technologies, and then the real role of commerce and commercial entities and the type of third-party data questions that raises. So with cloud computing, if it's infrastructure as a service, or if you have software as a service or platform as a service, you're going to approach it very differently depending on where the doctrine is. So in order to get to the instruments, you kind of have to understand the constitutional questions that are underlying them, which is what has forced FISA to the kind of camel that we now are presented with. So if I could have just a moment, I'm happy to talk a little bit about the Fourth Amendment and First Amendment issues. So I'll focus on the Fourth Amendment issues. And there are really three bodies of law in Fourth Amendment that are going to be directly relevant to a lot of the analyses that you have to do. The first one, of course, relates to digital data and persistent monitoring. And we're seeing the Supreme Court is becoming increasingly protective, and there is a warrant requirement if you're going to engage in this, at least as directed towards the United States. The second area is this open space doctrine, which we're seeing getting peeled back now with aerial surveillance and poll cameras, and I'll say a little bit about that too. And then the third area is this third-party doctrine. So on the first, persistent monitoring and digital data, if we think about the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure. Well, unreasonable at the time of the founding meant against the reason of the common law, and the common law forbade general warrants. So in the Fourth Amendment, we have a prohibition on general warrants, which are basically documents that are issued by the government to collect information to try to find evidence of illegal activity. In the second part of the Fourth Amendment, we have particularity, exactly what is required for a warrant to be valid. Well, the way this has come down is about 14 years ago in United States versus Jones, we had the first shot across the bow when a GPS chip was attached to a car as it went through public space outside of the warrant period. And in that case, although Justice Scalia, writing for the court, found that there had been a trespass on the car, a shadow majority in that case actually raised very serious concerns under the reasonableness analysis of the Fourth Amendment. So we look to that case as the shadow majority really standing up and saying, under a reasonableness requirement, this is problematic. And the particular language which Justice Sotomayor used in her concurrence was, unlike one's movements during a single journey, the whole of one's movements over the course of a month is not actually exposed to the public because the likelihood that somebody effectively will observe all of these movements is nil. And then she went on to talk about the length of that surveillance, the recording of the data, the volume and the type of information, the combination of it with other information, and the impact across society. So if you think about sensor technologies that are on satellites put in LEO or GEO, the number of people implicated goes directly into this calculation. The length of time that information is collected goes directly into this. Is it recorded? Is it accessible? Is it queryable? Now, a couple of years later, we had in Riley versus California, unanimous decision that a cell phone incident to arrest could not be searched without a warrant. And in that case, the court again doubled down on these elements. So it looked at the fact that there were multiple kinds of information, the volume of that information, the length of time, and the number of people whose privacy was implicated by that. And with cloud computing, they actually raised the issue of cloud computing in the case, saying, look, on the cloud, you have even more information. So it's an even deeper Fourth Amendment privacy interest. And then, of course, the crowning case is Carpenter. And when Carpenter was handed down, here you had 129 days, essentially, of cell phone records, cell site location information. And there, the court came out and said, no, this actually is a violation. They cited back to general warrants. They cited back to James Otis and his oration. The oration in Otis's case, which John Adams later said was kind of the first shot of the revolution, that we reject general warrants under the Fourth Amendment. And so that case has come to be understood as laying out the test that you would have to follow in any sort of reasonableness analysis for anything that's actually placed on a satellite. So they looked at, again, the number of people implicated, the type of information, the detail, how much they could actually pick up, the volume, resource constraints, that there were very few, the retroactivity, and the length of that collection itself. Now, under US versus US District Court, even for national security purposes, you do have to have probable cause and a third-party magistrate to determine it once that's a search. So that's the first body of law. The second body of law is open space doctrine. And on May 5th will be the 100-year anniversary of Hester versus the United States. Those of you who remember this case, it was actually, it turns out I've been looking into its history. It's this 15-year-old kid making whiskey, quite illegally. And he gets caught, and law enforcement comes onto his father's property because he's living at home at the time. And that's when we get open space or open fields doctrine established. Now, after CATS, there was some question like, well, what happens with open space doctrine at this point? But the court in Oliver basically says, no, open space doctrine, open fields doctrine is still a thing. You have no privacy interest in public. And then there's a series of Fourth Amendment cases that reinforce this. So we have Dunn in 1987, California versus Greenwood. This is when you put your garbage out. Since apparently our actions are the same as those of a raccoon, you have no privacy interest in your garbage. In Serralo, this was, I'm actually from Santa Clara. This is a case from San Jose Airport. I actually learned how to fly in a little Cessna 150. This was a Cessna 150 that flew over somebody's home in Santa Clara. And, you get the court in this extraordinary opinion saying, well, since anybody can sit on this can sit on top of a truck or on a double-decker bus, right? You have no privacy interest. And I found that incredible because there were no double-decker buses in Santa Clara. In fact, I looked up the Double-Decker Bus Association in America. There is one. There were 6 at the time in the whole United States. And it was illegal under 2 city ordinances and state law to sit on top of a truck at the time. Nevertheless, they doubled down on open fields doctrine. And then we have Florida versus Riley and a helicopter, looking at pot through a greenhouse, and Dow Chemical, right? That's all well and good, except now we're starting to see that being peeled back in a way that's going to affect what you do in Geo, as well as Leo. So in Jardines, of course, we have this as a trespass case where a dog sniffs for marijuana. Also, apparently, the police officer could smell it as well. We all know you can smell marijuana when people are using it. And in this case, Justice Scalia said, well, look, that's a trespass on the curtilage of the home. So the first point for USSPACECOM would be anything that goes within the curtilage of the home is going to be problematic for Fourth Amendment purposes, right? Because all of these cases, even the open fields doctrine, draw a line at the curtilage. The second point is both aerial surveillance and poll camera cases have gone the other way. So probably the most important aerial surveillance case is the wonderfully named Leaders of a Beautiful People versus Baltimore. And this was pretty recently when the Baltimore Police Department engaged in aerial surveillance of the Black Lives Matters marches, as well as general crime in Baltimore. There was an enormous public backlash. There was a case, obviously this case came forward, and the Fourth Circuit said, no, that's a search. Right. So if you're thinking about sensor technologies that are effectively conducting aerial surveillance for a persistent period over cities, the courts, or at least the Fourth Circuit, has said, no, that's a search within the meaning of the Fourth Amendment. Similarly on poll cameras, so this is the propensity of law enforcement to put cameras on telephone poles and look at people's homes, usually suspected drug dealers' homes. In Moore versus United States, we actually had a split in the First Circuit where they split 3-3 evenly on whether that was a Fourth Amendment search or not. The Supreme Court this past May did not take up that case. But if you look at the cases coming down the pike, we have a circuit split. So for the Ninth Circuit, that's a search within the meaning of the Fourth Amendment. For a number of actual state Supreme Courts, that also is a search within the meaning of the Fourth Amendment under the federal constitution. So they're ruling on federal constitutional questions. For others, the Fifth and the Eighth Circuit, they're kind of in the middle. Some cases think it's a search, some don't, say that it's covered depending on the circumstances. The Second, Fourth, Sixth, Seventh, 10th, and 11th circuits have a different view. They say that's not a search. And so this issue is getting primed up and ready to go to the Supreme Court. So that's one that I would definitely be paying attention to. The last body of law that I think is going to be relevant, particularly in light of the commercial nature of the satellites that are put up and the increasing use of cloud computing, is the third-party doctrine, which really came out of informant doctrine, all the mafia cases that came out, you know, Hoffa and so on, where they were wiring people to go into a drug house and somebody would say, you know, are you doing, you know, they would have a wire and somebody would be listening to the wire and the court says, yes, okay, that's not a search because you don't have a privacy interest in stuff you tell other people. So if you're telling other people, that's on you. Well, when CAPT came out, there was question as to whether informant doctrine had been actually interrupted. The court said no. Well, White in his concurrence, he said no, informant doctrine stands. And then 3 years later, we get this case, United States versus White, where the court says no, informant doctrine is still good. That then morphs into third-party doctrine with the idea in Miller that your bank records, even though they were required under the Bank Secrecy Act that you provide certain information, the court's position on this was you voluntarily give your financial information and your private information to the bank, so you have no privacy interest. And then in Smith versus Maryland, of course, we have Patricia McDonough, who's mugged in downtown Baltimore, and Michael Lee Smith, who there's this 1975 Monte Carlo, you know, that she sees at the time of the mugging, and then it drives by her house when she gets a call from Michael Lee Smith. He says, come out on your porch. She sees the same 1975 Monte Carlo drive past. She calls the police. The police see the car in the neighborhood. They run the plates. It belongs to Michael Lee Smith. And they go to the phone company and they say, hey, could we actually put this cool device called a pen register, trap and trace, on your line? We'd like to actually see if Michael Lee Smith is the one calling Patricia McDonough. It was. They get a warrant, they go into his house, and there's the phone book turned down to Patricia McDonough's name. So Smith says, no, that's private. That's private information. But at the time, you have these telephone operators who connect wires, and the court says, no, you told the phone company who you were calling, it's not private. And so we have the growth of third-party data. Well, that's also getting peeled back, mostly post-Carpenter. We're starting to see more restrictions on third-party data. So this raises all sorts of questions, especially when you have commercial vendors or commercial entities who are actually putting up the satellites or putting information on the satellites or carrying payloads or what it might be. So these three bodies of law have really had a deep impact on foreign intelligence collection and have forced a number of mechanisms to be introduced in order to address the constitutional concerns.
I'll open it up for the panel as well, but I guess my question after hearing that is, okay, I'm a member of the DoD. My focus is overseas at my adversary. Does that mean I don't have to consider, sort of in a space context, that I don't have to consider that body of law or that privacy interest?
So the answer is no. You still have to consider it, partly because of a case called Verdugo Urquidez, right, where Chief Justice Rehnquist issues his opinion in that case, and he says, look, any U.S. person overseas or non-U.S. person with a substantial connection to the United States has the reasonableness protections of the Fourth Amendment. So there is still a reasonableness analysis if it's a U.S. person that you're picking up outside the United States or a non-U.S. person with a reasonable connection. Now, the way foreign intelligence in the SIGINT world has gone about this is they've been very careful about the target that they're picking up, whose communications they're picking up. Is it a US person or not? Are they based in the United States or are they overseas? And then extensive minimization procedures. So not just standard minimization procedures, but special minimization procedures for instance, Section 702 collection. And then in addition, special querying procedures to make sure that if you're querying it using US persons information or trying to obtain US persons data, that you're doing so in a way that protects in a manner that's cognizant and consistent with Fourth Amendment jurisprudence. So you have the minimization procedures, the targeting procedures, the querying procedures, and you have kind of upfront requirements that you have to go to a court if it's a US person reasonably believed to be outside the United States.
So I guess I'll start with Lieutenant Colonel Goehring and sort of move down the line if you have comments. I would ask, based on that, how do we advise our DoD clients to sort of get at that question, and how do we help them design, to the extent that they're necessary, minimization procedures for that information that we might be gathering with space capabilities?
That is an excellent question. I think I would be best suited to defer that to my co-panelists. It's not an area I deal as frequently with.
All right, I'll bite at the apple. I think, right, so I agree with Professor Donahue in terms of the fact that, you know, these things do still apply in different fashion than they do in a traditional search if you're targeting a US person and those kinds of things. I think really what we need to think about is we are all now looking to buy commercial data or take advantage of space-based collection under operational authorities, right? We all know in this room pretty much what Intel oversight rules look like. We know how those apply. We know how those are structured. We've been trained and grown up in those systems. What does that oversight regime look like when it's not under an intelligence authority, right? That is something which we've grappled with in cyber extensively, right? You're doing cyber operations, think delivering a cyber effect against the adversary. There is still an element of data collection. That doesn't mean just because it's a foreign target and an adversary, doesn't mean there may not be ancillary US persons information. And so it begs the question of, do you have process and procedures in place on the back end that you are going to apply to this to ensure you meet those kinds of standards, that you can notify the appropriate overseers, and that to the extent you've got an inadvertent collection like that, your actions are reasonable, they're responsible, they're prudent, they're the kinds of things we expect of a well-disciplined military force, right? And so that to me is the challenge, because it is not something the folks that routinely deal with commercial data streams or operational data are used to talking about. But when you start talking about space-based collections or cyber collections, you are in a bulk data conversation almost by default. And so you need to have the appropriate prophylaxis measures in place so that you can appropriately handle it. And so I think it becomes looking at very detailed in terms of what kinds of data that you may get, where do you expect that you could reasonably expect to see some kind of US person's information, what kind of controls you have in place, and what kind of policies and regulations. I will caution you, avoid the urge to sit there and say, oh, we'll just apply the Intel oversight rules. The reason I say that is that makes a great talking point because everybody knows what they are and how they operate. But you will find in an as applied fashion in many of the operational paradigms, it doesn't work. And so you need to literally be able to kind of take the proverbial walk that dog through each step. And if you need to create new procedures to ensure protections, that's what you need to do, right? It's something that on the cyber side has worked so far very successfully, and you probably need to start being postured to do that with any kind of space-based data collections.
So just a quick two-finger, bulk collection has been outlawed, essentially, post-Snowden. When Snowden dropped the documents in June of 2013, there was a provision under the USA Patriot Act, Section 215, that was, the language is you have to have reasonable grounds to believe that the information to be obtained is relevant to an authorized investigation. And there was bulk collection going on of telephony metadata under that, internet metadata under the pen register trap and trace provisions of FISA. And when this all came out, Congress was extremely upset, having only 3 bills the previous year. When FISA was up for renewal, there were 42 bills in the 12 months following this information becoming public. And ultimately, the USA Freedom Act prohibited bulk collection of telephony metadata under either Section 215 or pen register trap and trace, or under national security letters. So bulk collection is not a really popular thing to be doing right now in the political domestic. Yeah, this is all domestic. 702, well, that's why 703 and 704 get introduced, is for US protection, so that in the international context, it's a different world, but there are still additional protections for US persons.
I would like to open it up to the, to Mr. Pennington and Professor Bailey to the extent that you have comments, but what jumps into my brain when I hear Captain Pascucci talking about, having that conversation with our operators and our commanders and making sure we are talking about, how do we wrap our hands around this, protect the information and whatnot, and to get at the underlying problem. I hear, Sandra, you're getting in the way of national security. You're not helping us get at the mission. How do I balance that? Do I really need to answer, do I choose national security over privacy? And how do I help my clients see that more clear or see it with me? Mr. Pennington, if you want.
Sure. Well, it's unfortunate that there's clients that bring that perspective. In my experience, they tend to be the somewhat younger, a little bit less experienced, more energetic, hard chargers, not exclusively, but they're more easily advised because that's not how we do things in America. We have a system of a rules-based approach to our operations, and this is what the rule is in this case. But more broadly, I think it's a false dichotomy when someone poses a question or presents a conundrum as, it's national security or it's complying with the law as it exists. Our system of law has enacted rules through a process that governs the totality of law in this country, and that governs how we do things. There are things we are allowed to do as the government and as armed forces, and there are things we are not allowed to do. And so if something violates a law, we have been told you can't do it that way. If you think you should do it that way, you're wrong. It's as wrong as if a higher echelon commander told you, hey, I want you to do this, but I don't want you to do it that way. Or if they told you, I don't want you to do that, right? They could say that for a lot of reasons. It could be a bad idea operationally, be an unacceptable risk to the force. It could be non-compliant with a controlling law that reflects the values that our nation has chosen to enact. And so those can be tricky conversations depending on how much control the person asking it has over your assignment and evaluations. But we owe them the same advice, right? Whether it's the hard-charging new kid or whether it's the general. And I've had to give essentially that advice to each. And of course it carries the day in the end. And failing that, there's always, look, don't do this because you're going to get in trouble, because you will surely be reported to the IG or to NCIS. And all sorts of problems will flow from this. And, this is how these rules came to be. Every rule that you're chafing at in the question that you've posed me, the notional commander or staff officer asking the question, every rule you're chafing at has an origin story. And that origin story was somebody who's just like you, wanting to do something just like this. So if you don't like the rule that you're chafing at, you're about to invite some more of them if you press too hard on this. Yeah.
The one point, there's one word that Todd used I want to foot stomp for you all, which was risk, right? To me, the best way to do this is you articulate this as risk to mission. Can you tactically pull this off now? Perhaps, but you've just put your ability to execute this mission in the future at great risk, right? And so that to me is usually a very effective way to have a conversation with commanders because they're used to thinking in terms of risk.
Also, excuse me. So this question comes up a lot in the area of investigations and intelligence collection as well. I have a response that it maybe is a bit too blunt, and that is when someone asks, well, isn't this an invasion of privacy? My answer is absolutely. Investigation is an invasion of privacy. It's an authorized invasion of privacy. It's one we do according to rules that are passed by Congress, that are overseen by courts. But that's because by and large, criminal actors tend not to walk in and provide us with all the evidence that we use to convict them. Similarly, foreign powers tend not to offer us the secrets they have that help inform senior policymakers to make the determinations they have to make. And so the question isn't whether it's an invasion of privacy or in some way invasive. In many cases, absolutely it is. The question is whether it is an authorized permissible invasion, under the Fourth Amendment, whether it's a reasonable invasion of privacy. So that again, it's not this dichotomy. It's, I think, both at the same time.
One thing I just want to add on from the SIGINT or cyber realm, really not SIGINT, but cyber and foreign intelligence realm is right now what we're seeing play out in Washington in regard to the Federal Bureau of Investigation is precisely this, like the lack of compliance finally got to a point where there's significant concern and proposals on the table, bills that would strip the FBI of access to foreign intelligence information because repeated noncompliance occurred and was not addressed, right? So when FISA is used, when it's queried for non-foreign intelligence purposes, and a statute says, well, you have to go to a judge before you do that, and they report they've done it almost 100 times and never gone to a judge, right? Or when a statute says you have to keep a copy of every US person query term, and they come into court and say, actually, we're not going to do that. Or when they can only query it for foreign intelligence and they use it for collegiate academies, for plumbers who go to the FBI, for members of Congress, for people who contribute to political campaigns, et cetera. It actually, the question, what do you need right now for this immediate concern, in some ways is the wrong one. It's what do you want the rule to be over the long term so you lose this capability and you're able to use it to protect national security.
And I'd like to add also, your point about foreign intelligence and your point about intelligence oversight. There's a lesson that's near and dear to me. It's tangentially related to those, but I come at it from a GEOINT perspective. And the lesson from intelligence law that's applicable to space operations for me is that GEOINT is kind of it's unlike other INTs. It's kind of peculiar and counterintuitive in that sense. In the intelligence law I'm thinking of, and more specifically the regulation, is DoD Manual 5240.01, which is DoD intelligence oversight. It addresses DoD intelligence, FI, CI, foreign intelligence, counterintelligence activities. Procedure 1 addresses that in its scope. Procedure 1 talks about the scope, but it also has a carve out. And that carve out is for non-FI, CI activities conducted under 2 particular statutes. Those statutes are 10 USC 442 and 50 USC 3045. Those are NGA's mission authorities. So 10 USC 442 directs NGA to support the GEOINT requirements of the DoD. 50 USC 3045 directs NGA to support the GEOINT requirements of other federal agencies. So the fact that this is there and carved out of the oversight manual is it's pretty important, because what it says is that NGA does things that are intelligence activities. It also does things that are not intelligence activities. And the only thing NGA does is GEOINT, Geospatial-Intelligence, statutorily defined as imagery intelligence, and geospatial information. So that means GEOINT itself is sometimes an intelligence activity, sometimes it's not an intelligence activity. So that's kind of counterintuitive. But I think it's important. Contrast that with SIGINT. SIGINT, I know we've got some SIGINT experts here, but from my perspective, SIGINT is always an intelligence activity. The use of signals for non-intelligence purposes is not called SIGINT. It's called electronic warfare support or electronic warfare. I think of it as kind of a legal fiction that's derived from various policies like in Executive Order 12333 that require that distinction to be made, but that's not the case with GEOINT. So what does it have to do with space operations? I think space operations are new in a lot of ways, and it's natural to apply an intuitive understanding, which may be like applying that SIGINT paradigm to your space operations. But it's not always correct to apply that intuitive SIGINT paradigm to space operations and to say this isn't GEOINT because it's not an INT. Not always the case under the law, and I think that's an important aspect of of intelligence law that we can apply to space operations.
Thank you for the sort of perfect segue, because I wanted to move into the second aspect of multi-domain lawyering that I think will lean on heavily in spaces where there's very little or real unclear law or unclear application of the law. We as lawyers sort of rely on arguing by analogy. And I kind of want to pose to the group whether or not the analogy to things like cyber and intel, does it work for space? Is it still valid? Is it still useful for a legal inquiry or legal review to use that analogy? And I think I open it to all of you, but I think I'll start with Mr. Pennington there.
Yeah, thanks, Sandra. I think that any sort of lawyering by analogy from space to cyber is very imperfect. There's a strong affinity between space and cyber that, in my view, is entirely accidental for some reasons that are specific to DoD. Namely, when commands needed to start bringing in cyber capacity or cyber capability to their formation, the place it was put was often an existing space command. And so as a result, a lot of space commands were dual-hatted as a cyber command, as in the case of Air Force Space Command, or in other cases, perhaps, I don't know the organizational history, a cyber command may be dual-hatted as a space command. Certainly Captain Pascucci is dual-hatted in a space, in a command that has a role as a space command and a cyber command. And why is that? Well, partly it's a matter of scale. The mission areas tend to be relatively smaller compared to others. And so to have leaders and staff competence of parity with their conventional counterparts, you need a bigger organization than the size of that comes with that capability might indicate. They tend to be, cyber and space tend to be outside each service's sort of principal operational focus, the domains of air, land, and sea. It's until the establishment of the Space Force, space and cyber were essentially an appendage on each service in some ways. And space commands were often chosen to be dual-hatted by virtue of having the resources and the experience and the legacy affiliation with the intelligence community. And so you had people who had worked with these matters on the intel side, and now they were picking it up on the military side. So that led to cyber being dual-hatted with space in many occasions, as a result of which many of the people transiting those commands tended to get experience in both. And so the experience got cross-pollinated. And so I think that's why there is a perception of a close affinity between space and cyber that is true, but accidental and largely irrelevant, I think, for purposes of legal analysis. The domains are totally different. For starters, space is a physical domain. Cyber is in some ways everywhere. It's in some ways nowhere. And at times it can exist, have a physical manifestation terrestrially or in space. It just doesn't have the same physicality as the other domains. In space operations, satellites move in very fast but very predictable and repeating orbits of movement. That is not true of cyber operations. The cyber activity can happen near instantaneously, nearly without warning. So the mechanism of action can be very different there. And just in terms of the operational dynamics, the access to space is still the hardest domain to get to. Access to barriers are going down all the time, but compared to air, sea, and certainly land, it's harder to get to space. Anyone can get to cyber. Cyber is after being born and, landing on the land here on Earth, the easiest domain to get to is cyber. And so that's why activities of non-state actors are so prevalent and significant in the cyber domain, because there is literally no barrier to access if they have an internet connection.
Pascucci?
Yeah, so no surprise, I have a slightly different view than Todd on this one. I actually think it's a perfect synergy, particularly for DoD. And the reason is because DoD likes to think of everything as a regional problem. right? And this is where I get into trouble with my geographic combatant command counterparts, because I refer to them as regional combatant commands because they deal with regional issues, right? And as Todd put it, right, look at the speed in space, something around 17,000 miles an hour or so, give or take, for orbits. That's a global problem, even if it's a single satellite you're talking about, just based on the way it's going to work. Same for cyber. And so in my mind, I see great synergy between the two. I completely agree with him that the legal regimes are fundamentally different. The technologies are fundamentally different. But I think some of the abstract problem sets we deal with from a command and control perspective, from a how we identify and try to articulate risk, both legal risk in domains that are still figuring out exactly how law applies, as well as operational risk, because senior leaders are not used to talking about those technologies. And so I think from my mind, I see a great synergy between them.
Thank you. Professor Whaley.
So I see both similarities and differences. I mean, for many of the reasons that were already discussed, I see that the one thing that wasn't mentioned, I think, is that both are rather immature in their development. And necessarily, the analysis is going to be done by some analogy to something in the virtual world, for example, or physical world, I should say. I mean, in my office, we spend plenty of time in Talmudic debates over like what is the appropriate physical world analog to whatever we're analyzing. One of the differences, I mean, I think there's an important question that both faces. When I started practicing cyber law back in 2000, good God, in my office, our position was it's no different than anything else, right? It's a computer is merely a file cabinet, a bigger file cabinet, but merely a file cabinet. And after 24 years, the courts are quite clear that that's not the case, that there is something specific to cyber that is different. I do think that space law may face the kind of law of the horse moment. Those of you who are familiar with law of the horse, 1996, Judge Easterbrook gave a speech at the University of Chicago during a cyber conference on something called the law of the horse. His point was that we have horses, we have veterinarians who deal with horses, we sell horses. Horses kick people and commit torts, and yet we do not have a law of the horse. His point being that there was no need to develop this thing that was particularized to horses. I think in cyber, we have an answer to that. We do have something that's different because of the qualitative and quantitative differences that the Supreme Court has noted in cases like Riley and Carpenter. One question will be, I think, in space, whether there are those same issues where one could point to something and say this is qualitatively different. I have a sense that there may be some. I mean, I think some of the issues around surveillance really are answerable by looking at existing precedent, at least domestically, things like Kylo versus the United States, remote sensing and emanations coming through a wall of a home being a Fourth Amendment issue, Leaders of the Beautiful Struggle case versus Baltimore, where, you know, aerial surveillance itself was ruled post-Carpenter as a Fourth Amendment moment. And so I think that there will be, you know, there are analogs that we can draw on that will answer this question.
So there are, I think, many similarities and differences, but one difference that I think is going to force the conversation when the law of the horse finally takes form to the back end is national airspace versus outer space. So, you know, if you don't want Baltimore Police Department to be surveying political marches, you're within national airspace. It's not like Russia is going to be coming into national airspace. Well, hopefully not, surveying political marches, right, in the United States. But when you're dealing with Geo or Leo, like you're in a different world, right? Like France, you know, and UK and Germany and whoever it is, Russia, they are flying overhead and they're collecting the same thing. And this brings us to what's really been vogue, or everybody's discussing now, is purchase of data, right? Like why would we stop our government from purchasing data if China can purchase the same data, right? And if we start having restrictions on the United States for what they can do over US territory, well, it's not as though China and Russia are going to stop what they're doing and they can get that same information. And that information delta does create a national security risk. So I think what we're going to end up seeing in the space domain are more back-end fixes like minimization procedures and querying restrictions and targeting restrictions at some level, but not as robust as in the cyber realm, because I think there's the non-terrestrial tie and the existence of, outer space as opposed to US airspace, I think is going to make a difference qualitatively in terms of what we need to do going forward to protect national security.
So, understanding time, I did want to go back to you, Lieutenant Colonel Goehring, on a point you made about the distinction between traditional military activities and intelligence activities. And I wonder in the area of space, right, where we have dual use capabilities, those capabilities are being used by different people for different reasons at different times. So one of the parts of multi-domain lawyering is sort of helping your client define the undefinable. But are those distinctions still tenable? Can we still do that? And how do we create structure around that?
I do think new capabilities are starting to create challenges. I see it often discussed in terms of roles and responsibilities, and I totally appreciate and echo what Todd says about it's not us versus them. But nevertheless, it is an ongoing discussion. Some elephants in the room were mentioned this morning, and I think this is another one of those. And I don't really want to wade into it, but I think it's helpful to think of it through a certain lens. And it makes sense to me to think of it as part of the convergence trend. I think the convergence trend is accelerating in space. And by that, I mean what Professor Bobby Chesney wrote about over 10 years ago, where intelligence activities and military activities start to converge, or they go from one to the other, back and forth, or organizations that typically do military activities begin to do intelligence activities, and organizations that typically do intelligence activities begin to do military activities. I think we're seeing that accelerate in space. The convergence trend, as Professor Chesney wrote, it's always been happening, but it's accelerated by technology, and we've seen that in the cyberspace domain. I think we're seeing it in space as we move towards an integrated GUN architecture in LEO. And so what I mean by integrated architecture, I can give a real world example on a smaller scale, and that's OPIR, Overhead Persistent Infrared Satellites. So the DoD has OPIR satellites that perform the missile warning mission. The IC has OPIR satellites that collect on the Director of National Intelligence requirements from the National Intelligence Priority Framework. But these satellites work together. They are integrated, and you can read more about how that works through the Joint OPIR Center in Joint Publication 3-14. But yeah, it's an integrated system, and that is, we do it that way to avoid the problem of a kid's soccer game where everyone's focused on the ball. Everyone doesn't need to be focused on the ball, but in the meantime, you're missing things that you could be focusing on. So I see OPIR satellites help perform the missile warning mission, and they help to fulfill combatant commanders' demands and requirements. And conversely, the DoD OPIR satellites help to collect on the DNI's requirements, and that's an efficient and effective way to do it. And I think we are going to see that in a much larger scale with the coming integrated GUN constellation, where all these constellations are working together to fulfill all the requirements. So the thing about the convergence trend is that it challenges the legal architectures. The legal architectures that are challenged in the cyberspace domain are not necessarily the same as the ones that are challenged in the space domain, but there are still challenges. And the reason is because the legal architectures they can't deal with convergence. They're not constructed that way. They're constructed to deal with silos. These are military activities. These are intelligence activities. And when those start to converge, it becomes a challenge. So we have to kind of, I think it helps to acknowledge that there's not necessarily an answer in the law because the law is being challenged. And it may take changing the law, like some changes have been made in the cyberspace domain. And maybe that's the case we'll have to see in the space domain as well.
Thank you for that, sir. And I think it sort of segues really perfectly into sort of asking our last question before we open the floor for questions is to say, okay, I take that convergence and I put that against the recent note from the White House that said, talks about novel legal frameworks for novel space activities. And it sort of says, hey, we need to create a framework around these things and allow it to be flexible and transparent and move with how capabilities develop. And I think I'd like to go first to Professor Bailey, just from the perspective of the Computer Fraud and Abuse Act, right? So from that perspective, how do we inject that flexibility where we as lawyers want to define certain words in our statutes?
Right. So the CFAA, the Computer Fraud and Abuse Act, 18 U.S.C. 1030, is sort of the premier federal hacking statute. I think it's an example of a statute that actually will likely apply to sort of space hacking, for lack of a better term. Under the statute, it applies where there's action, accessing a protected computer without authorization. A protected computer is defined under the statute as one used in or affecting interstate or foreign commerce. I think you can probably shoehorn a satellite in under that pretty broad definition. I do think that one of the areas where some greater thought is necessary is the issue of harms in space, right? So as I mentioned, I think surveillance laws are generally, there are analogs that we can find, I think, in sort of the physical world. I think there are questions about whether there are harms that relate to space that are unique to space law. So if you affect a satellite, is that different than affecting other types of property? From the standpoint of one, the harm at scale, like the amount of disruption or network congestion or things of that sort that you can cause with that, but also the difficulty in mitigation, right? This is not like something that you can call Geek Squad and repair. This is something that with great expense and effort, you're going to have to address. And so does that difference, is that qualitative enough to say, this is something different and we have to impose sort of different laws around potential harms to this? So identifying those types of things, I think, are going to be important. I do think, going back to Easterbrook, I do think a lot of existing law will cover activities that happen in space. So one thing I would kind of urge folks to think about is something that maybe learning from us in law enforcement as in something we didn't do well. I think we were slow to realize exactly how great the impact of nation-state actors was, and the degree to which nation-state actors were on our networks. You have the problem perhaps in reverse. In the future, when people think of space conflict, they think of nation states in conflict. You may want to consider a world in which criminals actually begin targeting satellites. Why would that happen? Well, one of the things we've learned for the last few years with ransomware is the ability to leverage harm for extortionate purposes is something that many criminal actors excel at, particularly those who are sophisticated criminal transnational actors, many located in Russia. Is there a day in which they would choose to target satellites to achieve the same ends? And we know that some of the ransomware and extortion attempts have targeted not just individuals, not just companies, but also government entities. And if that's the case, just to be clear, DOJ is not saying you should run out and start, arresting criminals, but rather maybe think in the same way we had to about whether the toolkit of authorities we have to deal with that type of problem is in place, and if not, how that has to be built out in the interagency and otherwise to get there.
So we've got about 11 minutes left. If anyone has a final comment, we'll open to the floor. Aubrey, if we have first from the online folks.
We do. The first question is, what are the Fourth Amendment implications of private commercial remote sensing companies when many of them are also government contractors? The government oversight gives access to data that they would probably need to go ahead and comply with under Article 6 of the OST. What are the panel's thoughts on that?
Okay, so in terms of the Fourth Amendment issues with contractors, like obviously you're going to be dealing with third-party data type issues, but how far the government can go, that's some question in terms of forcing compliance and providing information to the government itself. So we were actually talking earlier about the 1934 Communications Act. There's actually a provision there that allows the government to take over telecommunications companies. And so those of you familiar with Youngstown, Sheet and Steel Company, might find that somewhat surprising, because when Truman tried to take over the steel mills, it did not go so well for Truman on the grounds. You know, we have Jackson's concurrence that if Congress has acted and passed legislation in the area of foreign affairs and the president acts consistent with those authorities, right, you're at the zenith, the height of your power. Well, if you had a telecommunications company that maybe had a payload on their satellite and was refusing to tell you what it was, assuming they know what it is, could you take over that telecommunications company under the 1934, under the satellite company, under the 1934 Communications Act? Well, if we play that out, you know, maybe your legal advice is actually statutorily you can, and under Jackson's concurrence, you're at the zenith of your power. On the other hand, if you have a bunch of 20-somethings in hoodies eating Doritos who decide not to show up to work that day, how exactly are you going to run that company if you lack the expertise to get the information you were trying to get, right? And that pushes us back into this conversation of how do you get information from private contractors or private companies when you need it in terms of the satellite technologies. Leonard, do you want to?
Yeah, this is coming up a lot for us in the world of public-private partnerships. And as it sort of manifests for us, there is this issue. There's a line of Supreme Court cases and other cases, Skinner versus Railroad Executives Association, that goes to when there is basically government agency, when a private actor is actually acting as an instrument of the government. And, you know, in general, the notion is where there's direction and control asserted by the government or knowledge and acquiescence, but there's a multi-part test, you know, on for whose benefit is the action taken, for example. You know, is this volitional activity? Are there regulations that are directing this action? And the impact is that you may have private actors who are either providing information to the government to be helpful, or in other contexts where their activities are triggering both Fourth Amendment and particularly statutory prohibitions. And so something to watch for is, and this comes up not just in operational conduct, but also where we're purchasing data, when other private actors are so aligned with the government that their activities might actually be viewed as government activities triggering all of the kind of relevant constitutional protections, but also some of the obligations under statute.
This actually happened in the poll camera case, where a neighbor, the terrible neighbor, right, 56 days, put their neighbor under surveillance with a camera on their property at the behest of law enforcement. And the court said, no, that's a Fourth Amendment moment, even though it's a private actor doing the collection, because they're doing it at the behest of the federal government.
A question from the floor, or we've got about 7 minutes left. If not, we'll go back online.
So, yeah, this one has to deal with legislation by principle. And I know we've seen some examples of this, especially coming out of California, as you might be fully aware. But the question says, not fully knowing the capabilities, weapons, and effects of military operations in space is the only possibility for the creation of law, perhaps legislation by principle alone.
Sorry, did you say by principle alone?
That's correct.
I'm not sure I understand the question, Hobbs. Legislation by principle alone?
That's how it's phrased. And so
Yeah.
if I'm understanding the question properly, like, for example, California recently has been working with some legislation where we're saying, hey, legally, we are agreeing to abide by these tenets of artificial intelligence, or, so that the legislation drives the adherence to an ethical principle or some other larger construct. it's something that's being experimented with, but when we're dealing with these types of capabilities in a largely kind of unknown area, perhaps there's some discussion there.
I'd suggest that actually happens a lot in practice, in the form of committee reports, which are of which the department and every government department takes note of, where the views of Congress are expressed through that committee reporting process. It's not legislation as such, but certainly nobody disregards it. There's already a mechanism where a sense of Congress can be enacted in legislation. I'm afraid I don't have an example on the tip of my tongue, or even necessarily think that might be that helpful, since so much of what we're legislating in space is in the form of regulatory activities. There's already a fairly broad brush in what's regulated, consistent with national security, preserving U.S. leadership in space, preserving perishable technological advantage, and the like. Those principles are already present in the different regulatory regimes and their parent statutes. So the real work of much of that, of those cases, is in the eaches of the regulatory adjudications. I'm not sure if that's a helpful answer or not, but short answer, I think that is actually already happening to some extent in that sense, and then we see it manifested in the outcome of it through the regulatory process. Any other takes on that from my esteemed panelists, Brian?
I'll back you up on one point here, Todd, right? Which is, that sounds great, except what does it look like as applied? Right, that's the challenge, is right. Law is supposed to give you a sense of predictability in its application, and I worry in that circumstance that the as applied starts varying across. And so, as a practitioner, like down at the tactical level, that would be my concern with that construct.
That's a fair point. If we only take smart risk, what does that mean? That's a helpful principle, like in concept, but you can't really do anything with it in practice. It's too fuzzy.
In the last few minutes.
Thank you. Good afternoon, Major Brian Green, Starcom JA. I think my question is similar to the first one that came in from online, but in light of what you've been discussing in terms of third-party doctrine and convergence trends and applying things like the CFAA to third-party activities, what do you make of the fact that there are commercial entities out there now trying to offer SIGINT as a service, something that's traditionally been the domain of government? How should we think about that from a legal and national security standpoint?
Okay, so I'll take a first crack, right? That scares the daylights out of me, right? And I'm not joking on that. I've seen that in my time at SOCOM. I've seen that in my current time, right? And so it sounds great to the client, right? Because they're usually capacity limited, yet dollars they can get easier than personnel or gear. And so they're like, well, lawyer, what's the problem, right? Like, we're going to go through the contracting process. And so what worries me, what I encourage you to take a look at is, do you have checks in your contracting process by your ops lawyers? Because the contracting folks are usually really good at, offer acceptance, defarge provisions, and everything else. But do they know what they're looking for to see that you're just contracting out an operational activity? Right? I've personally been involved in a scenario where that got missed, and then we had to figure out how to walk back on a contract. Right? That's a challenge. And so that does scare the daylights out of me.
At the very least, I think, in my personal opinion, it needs to be regulated, authorized, and continually supervised under Article 6. It strikes me as peculiar that people often cite the regulatory gaps that apply to these near future activities, and here's one that's already on orbit happening that doesn't fall under remote sensing regulations or really anything. So I think that would be a start.
I've been concerned for many years about no export controls on data and information. And this is finally starting to come of age. We finally had an executive order issued, last week that 6 countries, we're going to actually limit the sale of data because of course you can't sell it to somebody else who sells it to them. Of course, that's going to happen, right? Like, I've been very concerned that we don't have enough export controls because that data can be so powerful. And if they're selling it to us, then they could be selling it to others as well.
Brian, you'll recall this from our working together. It's considerations like that that prompt us whenever we're reviewing a commercial integration strategy to advocate for the inclusion of at least a passing mention of the concept of inherently governmental activities. So that's always part of the calculus. And that's, whether it's because it requires combatant immunity, whether because the nature of intel oversight simply requires it, or otherwise. And then be prepared, because once you finally get the client past that, the next question will be, well, if we contract for this, how do we ensure without fail that it will always be there in time of war when we need it? And of course, it won't. Don't contract it if you need it like that. You need to have it of your own if it's so vital that that it's mission failure if the contractor cannot deliver in hostilities. So yeah, thanks.
Please join me in thanking my team for a wonderful conversation. Thank you so much.
And thank you very much, Major Ahinga and our panelists. If there's one lesson I've learned, it's always thank your speakers. So please accept this token of our appreciation.